This is David Olshan of Nevada Legal Services. This is our ongoing YouTube Law School, and this session covers discovery, the first steps after filing your complaint. So discovery is required for complaints or is otherwise ordered by the court. Petition for judicial review, appeals, writs, small claims, summary eviction. There's no discovery in those cases. There may be in a writ if the judge orders it. And again, if you're filing a complaint, you will have to engage in discovery. Failure to participate in discovery may cause your claim to be dismissed, so it is important. If this is too complicated or difficult for you, please review the small claims rules, because if you can reduce your claim to $10,000, it's a small claims action and you can just go in and plead your case and we'll get a judgment. It's quick and it's easy. It's made for non-lawyers. If you cannot complete these requirements and discovery requirements and don't want to go to small claims court, you may want to consider hiring an attorney. And the thing to keep in mind is if a defendant is represented by an attorney, ethical rules require the attorney to be fair to unrepresented parties, but they usually never are, as you can probably guess. This means you may get oppressive discovery requests, a long deposition, frequent motions. So just be advised, it's a jungle out there, and if you are unrepresented, you are at a disadvantage in our court system, and attorneys and judges take advantage of you. So initial disclosures are required in federal court and state court. In federal court, without being asked, you have to supply the defendant within 30 days of the defendant answering or filing a motion to dismiss or otherwise appearing. You have to supply a list of your witnesses that you intend to call at trial, a copy or description of any document that you intend to use at trial, computation of damages, and any documents that support those damages, and a copy of any insurance coverage that may cover the claim that you're raising against the defendant. You must disclose these, you must produce these without any prompting. There's also a 26F conference, basically a call or a meeting with opposing counsel to talk about discovery and create a discovery plan. In state district court, the disclosures are pretty much the same. The list of witnesses, the documents that you have, the damage computation. This is not a 26F conference, it's a 16.1B conference, but it's similar. At the 16.1B conference, you basically set out your discovery plan. This is held within 30 days of the first defendant answering, so it's a little bit later in state court. There must be a case conference report that must be produced and filed with the court that basically sets the discovery deadlines and guidelines. So just be advised, these are requirements. As a plaintiff, it's your responsibility. And if these are too difficult, you need to hire an attorney or go to small claims court. Justice court, if you're filing in justice court, discovery is only upon permission of the court. Again, if this is too difficult, if you don't want to go through discovery, file a small claims action. Justice court claim limit is $15,000. The small claims limit is $10,000. If your claim is $12,000, just give up those $2,000s and go to small claims court. For unrepresented people, if you don't want to hire an attorney, go to small claims court. It's quick, it's easy, it's set up for people who aren't represented by an attorney. Again, you must file a 16.1 report in state court or a 26F report in federal court. And these are plans on what you intend to do with discovery, how long it's going to take, deadlines, and things like that. So interrogatories, requests for production, depositions, they all happen after these early case conferences. And again, if this is too complicated, please consider hiring an attorney. We are Nevada Legal Services, and we do provide representation in some of these complaints and some of these actions in federal or state court. Please do an online intake at nevadalegalservices.org. And the last lesson of the YouTube Law School will be in the next few weeks regarding the judgment and appeals.